So thank you for everybody. This time I'm very honored to invite Gabriela from Michigan this times because she is the expert of the data protections and the privacy regulation this moment. She works at the FPF, Future of Privacy Forum. This is the think tank on Washington, DC. So great to have you this time, Gabriela. Thank you for coming.
It's a pleasure to be here, Kohei-san, to talk to you and to your audience. Thank you.
Thank you. So first of all, I'd like to introduce her profile. Dr. Gabriela Zanfir-Fortuna is a senior counsel for the Future Privacy Forum, where she leads the work on global privacy developments of the European data protection law and policy, with their impact on all focuses area of FPF, including the identifications, AI, mobility, ad tech, on all focus, education, and any areas. Previously, she worked as a legal officer in Brussels for the European Data Protection Supervisory. Gabriela has a PhD in law with a thesis on the right of the data subject. So again, thank you for coming, Gabriela, this times.
My pleasure.
Thank you. Yeah, let's move on to today's interview agenda. I'm personally very interested in your histories to dive into the privacy field because we have many people is working on these times, but we have different reasons why we come to the privacy market. So could you tell us about your history, why you are come to the privacy field?
Yes, absolutely. My pleasure to recollect how I got into the field. So at the very beginning, I was interested in privacy during law school when we were studying constitutional rights, fundamental rights, and we were studying the right to privacy as well, the right to confidentiality of communications and so on. And I remember reading the theory of it and then remembering from the stories of my parents and of my grandparents who lived in Romania under the totalitarian regime of communism up until 1989. And I was remembering particularly my grandfather's stories about literally neighbors that were listening into his conversations, listening into the type of radio programs he was listening, and then they would go and tell the secret police. They were actually working, collaborating with the secret police and helping the secret police keep a file on him. And I was fascinated by the idea of how individuals and societies can protect themselves from surveillance, from the surveillance state. So I did a lot of research around that. And this is how I came across the field of data protection law. In Europe, in the European Union legal structure, privacy is actually a different fundamental right than data protection. They are actually connected. However, they are protected differently. They are even protected differently in the European, in the Charter of EU Fundamental Rights, because one of them is under Article 7, that's the right to respect for private life and confidentiality of communications and family life. And then the other one is under Article 8 of the EU Charter, which is the right to the protection of personal data. So, you know, starting from this fascination that I had on surveillance society and the impact that surveillance society had on people's lives, I started to be interested in the field. And then I discovered that, well, the field is actually very
Mhm.
complex. You have the privacy aspect of it, and then you also have the data protection aspect of it, the protection of personal data aspect of it. And that's the very beginning of the story. And then I became fascinated with data protection after participating to a moot court competition. This is something typical to law school students. It's like moot court is a competition where law school students act like lawyers. They have to solve a case, they have to defend, or to be on the other side, the side of the applicant to a case, in a case, and sort of pretend to be lawyers. And I participated in one of those competitions, and the case was about data protection. And it was about the data protection directive of the European Union. And I was fascinated about the field. I started to read a lot about it. And ever since then, which was I think around 2008, if I remember correctly, I never stopped. So I started, and then it's a very generous subject matter. You have a lot of complex notions that you can explore. It has an immediate impact on society, this field, and an immediate impact on people's lives. And I found it fascinating. But then I did my master's thesis, my master's of law thesis on this subject, and then I started my PhD research on this subject. Yeah, so that's the long story. I told you both the short and the long story.
Yeah, that is very inspired with me. Since I've seen in the many videos that you were talking about the privacy, then those old experiences is the inherit to your passions or missions, why you involves this space. That is we also working on the privacy space, and we also our own inspiration that is very great to share each thoughts the why you are coming to the privacy fields. So I'm wondering also that you are reading the Future Privacy Forum, the many subjects that is very important to encourage the privacy market, the privacy involvement with many people, not just only for the regulators, the policymakers, but also the tech peoples or business person there. So how did you get to start with the Future of the Privacy Forum, and what is your main role to lead these organizations?
Yes, so I started to work for the Future of Privacy Forum in 2016 after I moved to the United States from Brussels. I moved here for personal reasons. And then when I was looking at the job market, I thought that the Future of Privacy Forum would be a very good place to start my career in the US. And I was right. You know, I'm very lucky to work with my colleagues. And I learned a lot from them about the American system. And at the same time, I was able to tell them about the European system and how we are looking at these things from the European Union law perspective. Just before I moved to the US, the European Union had just adopted the General Data Protection Regulation, the GDPR. And I was lucky to be a part of that process because my former employer, the European Data Protection Supervisor, is actually the official advisor of the European Commission, European Parliament, and European Council whenever they adopt a law or they are in the process of adopting a law that has anything to do with processing personal data. And given this special advisory role that the European Data Protection Supervisor has, the EDPS was invited, of course, to give his opinion on the GDPR and the draft of the GDPR and the discussions, the debates that were happening in Brussels at that time. And I was working there during the legislative process of the GDPR, and I was part of the team it was an incredible team of very smart people, the DPS, that were analyzing the draft, were analyzing the GDPR proposals, and were advising from an independent point of view all of the institutions that were involved. So with that knowledge, with that body of knowledge, and after the process of adopting the GDPR was completed, when I moved to the US, I was in a very lucky situation because everybody in the United States that had something to do with the personal data and collecting and using personal data, and that had a business in Europe to they were actually very much aware that the GDPR will enter into force in 2 years' time. And they were very open to hear about why the GDPR has some rules in place, and to sort of have someone to explain that, all of that to them. And I was that person, right? So I could explain to my colleagues at the Future of Privacy Forum what the GDPR, how it was built, what it was meant to achieve, and how it should be complied with, at least theoretically at that point. So I kind of became the expert voice on EU privacy and data protection within the organization. So I was leading that work. And since the General Data Protection Regulation applies to all sectors across industries, and it is technologically neutral, it's actually very relevant for online advertising, for biometrics, for artificial intelligence and machine learning, for children privacy online. So it actually permeates, it touches all of these sectors. And this is how I got to work with all of my other colleagues that were focused and that are doing leading work on each of these sectors. I was able to support their work with the GDPR angle, let's say. And then most recently, in the past year, I started to work a lot on global privacy trends. And this is because I have been seeing significant developments in jurisdictions around the world. And Japan is a prime example of that. There's a lot happening there, right? But then there are also other jurisdictions where there are significant developments that are very interesting to observe, to understand, to analyze. And for example, Brazil, for example, India, South Korea, Singapore. There's a lot happening in Africa as well. So we've seen developments in South Africa, in Nigeria, in Kenya, and it's really a pleasure now to be able to do this work in global privacy and to be able to understand these trends.
I see. Yeah, that's a very broad work, then very excellent to collecting the global information to develop more privacy protected, the relationship in each global jurisdictions. Yeah, you have seen the many experiences from Europe to US, the other countries' development at this moment. I want to move to the more practical questions from your experiences. As you mentioned on the histories that you had experienced in Europe for the data protections. The last 3 years, Europe and US is made a very controversial dialogues related to the data transparency, especially the privacy frameworks. So my question is, how has been discussed the privacy shield, which is the privacy framework, during the bilateral countries so far? Is that positive or negative? Which direction there?
That's a very good question. And indeed, the international data transfers, and particularly transfers from Europe to the United States, are now some of the hottest topics of privacy. And this is because, as we know, last summer, the Court of Justice of the European Union invalidated the EU-US Privacy Shield in a case that actually continued an older case from 2015, if I'm not mistaken, when the Court of Justice had annulled the previous arrangement for transfers between Europe and the United States, the safe harbor. And the Court of Justice has some concerns related to the independent oversight of surveillance activities here in the US. It also has concerns about the proportionality of the surveillance activity itself, and particularly the collection of electronic communications data that are coming from Europe, and how that collection is or is not proportional. Other concerns about whether European residents and citizens, once their data is being transferred here in the US, have a right to judicial redress. So these are the key concerns of the Court of Justice. And because the court believed that the standards ensured by the Privacy Shield do not meet the standards in the EU Charter of Fundamental Rights, the court decided to annul the Privacy Shield. I would say from the look of it right now, the European Commission and the US government are working to reach a new agreement, taking into account the court's concerns. The process is ongoing. There are negotiations that are taking place. It was a very good sign in this perspective that the new administration here in the US appointed a person in the first day of the Biden presidency on 20th of January. A person was appointed to be the responsible to carry on this negotiation with the European Commission. So, you know, discussions are ongoing, and that's a good sign. And we are all waiting to see what is coming out of the negotiation now.
Thank you. So until the framework has been established in between the both countries, maybe you have to use the SCC standard contractual clauses. Maybe the almost 5,000 of the US company has been used the framework, but they have to change their direction to the contractual based. So is there any impact for the company at this moment right now in US or European companies?
There is an impact, at least in terms of risk and compliance risk, and risk to be fined if you don't have a contract, like a standard contractual clause type of contract in place with the data exporter in the EU, or from the other point of view, with the data importer in the US. There is certainly a risk now that the Privacy Shield is gone. There needs to be a lawful ground for processing in place. And the options are quite limited, right? Because you have indeed standard contractual clauses, but then it's a bit tricky because the Court of Justice in the judgment kind of suggested that, at least when it comes to transfers to the US, some supplemental measures are needed on top of the standard contractual clauses, usually of non-contractual nature, so usually of a technical or organizational nature, to ensure that the data that comes from Europe is protected. So, you know, the situation is a bit complicated. Then, of course, there are some other options too, but they're just not very comfortable to use and to reach. For example, there are the binding corporate rules. That's one of the possibilities for intra-group transfers, so for transfers in the same group of companies. However, it takes a long time for binding corporate rules to be approved by data protection authorities in Europe. It might take 2, 3, even 4 years sometimes. And until they are approved, the transfers are under shaky ground. They're uncertain, their legality is uncertain. And then there's also the option of the derogations under Article 49. But the European Data Protection Board has clearly stated that the derogation should be used in very limited ways. They should not be used to allow massive and repetitive transfers. So there's definitely a risk here for companies that are still doing transfers. However, I have not yet seen action from data protection authorities in Europe. I think they want to be very thoughtful about this issue. And I think they want to finalize the guidance that they have been working on. They have already published a draft version of guidelines to companies on how to proceed until a new framework is established. And they have received a lot of comments from companies and from consumers, from NGOs. And now they are incorporating the comments, and hopefully we'll see final guidance soon. So, you know, to describe it a bit, the situation is uncertain. This is the word I would use.
I see. Yeah, I was watching many processes. I also have some friends in US. They said like this invalidation is very influential for the data operation, especially the cloud services, is that now works in between the US and Europe. That was very influential for those private business. Japan is in advocacy these times, but we are not sure if we are updating an each agreement between Europe and Japan again. So that was a very big impact for the private companies in case those advocacies no longer to be retainable. So that's one way that I'm considering. So yeah, next question is about your European experiences. In Europe has started the GDPR almost 2.5 years ago. Since some instance is coming up, the almost 500 at this moment. But the problem is about for the big tech regulations, especially the Facebook, the Twitters or Google's, those businesses, the widespread, not just in remaining the US, but they do the business in Europe. In case for the enforcement under the GDPR, it's a little bit complicated structures for Japanese or Asian countries. I think it's called a one-stop shop the system. Then you mentioned on Twitter that the system needs to be improved more effective. So what is the issues of the one-stop shop and what they need to improve for the effectiveness?
So indeed, the governance structure is quite complicated under the GDPR. Just to try to give a summary of it for your friends and your audience, it's like this. Every country that's part of the European Union has one data protection authority. I think of the equivalent of the Data Protection Commission in Japan, or the Privacy Commission. Actually, Germany has 16 data protection authorities in each state of Germany. But then also it has a federal data protection commissioner, and so there you go. They also have the federal one. Now, all of these data protection authorities from member state level meet in what's called the European Data Protection Board. And this is a separate EU agency, a separate agency of the European Union that was created by the GDPR, and that reunites all of the commissioners, the presidents of the data protection authorities in some of the countries in a plenary to discuss and make decisions together. Now, this one-stop shop mechanism was included in the GDPR with a couple of purposes, but one of them was to literally become a one-stop shop for those controllers, those companies that use personal data of citizens and residents in multiple countries in the EU. Prior to the GDPR, what happened was that if a business had clients, customers in 4 member states, they would need to communicate and comply with the guidance of 4 data protection authorities in each of these member states. Under the one-stop shop rule, the idea is that such a company that has activity in several member states can have just one data protection authority with which they communicate. That's their lead regulator. It's called the lead data protection authority. And they are under the jurisdiction of this data protection authority, and this data protection authority can impose fines, for example, can start investigations and so on. However, the thing becomes complicated because the data protection authorities of the other member states where a business has clients, customers, data subjects, right, the individuals that whose data they process, are also interested to protect their own citizens, their own residents. So they have an interest in cross-border cases. So therefore, what the GDPR is doing, well, within the European Data Protection Board, the GDPR created a mechanism of cooperation between all data protection authorities that are interested and the lead data protection authorities. Now, the problem is that this process is very slow, especially, this can happen when a particular company actually has business or processes personal data in all of the 27 countries of the European Union. That's a lot. Everybody is interested to have a word to say to protect their own citizens, right? And it may take a long time before consensus is reached. So this is, data protection law is the first area of law where the European Union is trying this type of governance model. And I don't know exactly. Let's see. I mean, it's been 2.5 years since the GDPR became enforceable. We have not seen a lot of cases coming out of the one-stop shop yet, but there is some movement there. So I would say perhaps it's too soon to say exactly how things can be improved or to point exactly to a specific problem. Also think about the fact that the people working for data protection authorities, the staff, needs to get used to this collaboration and to this working together as well. So it's a very complicated governance structure. It's the first time the European Union is trying this, and the jury is still out on whether it will properly work like, a German engine in the end, or whether some adjustments will be needed.
Thank you. Yeah, I suppose those structure is not just in Europe in the futures because of the personal data is been transferred to the international market. So that's that we have to cooperate with the international collaborations in between the jurisdictions need to be like cooperative approach to investigate it than the internal operations. So that is more complexity than the futures. So that's why we have to make a commitment to take some of the progressions to take a conversation in advance. We have a different granularities of the regulations is that very complex in each others. So that we need to be shared and resources, the informations, the needs to educate people to the enhances the infrastructures. So yeah, that was a very knowledgeable for the listeners about the realities of the enforcement. So the last topic about the future landscapes, and you moved to the US this time, and US has replaced new administrations. I suppose they are directions to the more democratic approach for the data market. And you had published a very great article and the three parts of the elements why the US new administrations has a strong leadership of the privacy regulation in federal. So how do you expect the new Biden administration to actually lead this regulation in US?
Yes, that's a very good question. There have been a lot of things happening in the US in the past 3-4 years, I would say. There are several things that are very important. First of all, we have seen action at state level. For example, California. Well, California is actually the strongest example of things where privacy legislation is happening, because California passed the CCPA, the California Consumer Privacy Act, in 2018. And very recently, in November last year, the people also voted in a referendum. Here it's called the ballot initiative, but it's technically a referendum, a legislative referendum. They voted a law to replace the CCPA, which is more complex than the CCPA and which provides better protection to privacy. The CPRA, the California Privacy Rights Act, or I think I got it right, but in any case, it is the CPRA, and the CPRA is supposed to come into force in January 2023. So with this action in California, the bar was raised for, first of all, for other states to step up and to adopt privacy protective legislation for their own citizens, for their own constituents. And the bar was also raised for Congress at federal level to propose legislation to provide privacy protection for all Americans across sectors of the economy. Because what's happening right now in the US is that there is some privacy legislation in place at federal level, but only for specific narrow sectors. For example, we have HIPAA, which is the Health Information and Portability, Health Information Protection and Portability Act, which only applies to health data held by hospital, by healthcare service providers. And then there's also a Fair Information Credit Act that applies in the credit reporting industry and so on. But there's no privacy legislation, there are no standards that are general and apply in every type of private activity. So this is where a lot of things are happening now, both in other states. Actually, Virginia is very close to adopting state comprehensive privacy law. I know that a lot of people here in the US would actually challenge the idea that the law is comprehensive. They would say that it's not really comprehensive because it has some exceptions. But the reality is that the law in Virginia will actually apply across business sectors. So it will apply every private business that meets a particular threshold of activity. It does not apply to small medium businesses. And it actually has a lot of the safeguards that we see in California already and that we see in the GDPR. So the GDPR also had a bit of an influence on these developments. There is another bill discussed, another legislative proposal discussed in Washington state. That is the state in the northwest part of the US where we have Seattle. And for 3 years in a row, legislation was being debated there. And we're waiting to see whether this time around it will be adopted or not. We'll find out soon. And then at federal level, in the US Congress, we are seeing a number of legislative initiatives that were already introduced last year or in the past 2 years. And that I hope at least one of them will actually gain momentum and we'll finally see at federal level a comprehensive or baseline privacy legislation passed.
Yeah, thank you. That's very aggressive to many things. This happens at this moment. Since the new administration is a strong leadership in this space, maybe the US data landscape will be changed, not just only for the tech company or other businesses as well. Thank you. So lastly, I'd like to be given a message to all the listeners from you. And you also working on the privacy space. You are seeing this new landscape. Maybe there's some Japanese privacy leadership or privacy regulator is seeing these interviews and happy to be given your thoughts, the ideas for them.
Yeah, thank you for that. Well, first of all, I want to say that it's great that Japan and the European Union have this mutual adequacy regime in place. I think that is fantastic. It's such a good sign to be able to freely transfer data from Japan to the EU and then from the EU to Japan. And from this point of view, I think Japan is truly a leader on the global scene. I would also say that I highly appreciate the initiative of the Japanese government for the data data flows with trust, initiative in the G20 framework. And I think that was a much needed voice to be heard, a much needed initiative for democratic countries to come together and agree on standards that would allow for data to be transferred across borders in a way that raises trust in citizens and trust in other governments as well. So that is really, really good. And I think that Japan is really on the way to be a leader, a global leader in this space. So I'm very happy to see that. And I hope this trend will continue and we will get to see a lot of innovation in data protection coming from Japan. I've seen a bit about the amendments that were passed last year to the law. And I'm very excited to see the leadership of Japan in this space.
Yeah, thank you, Gabriela, having a great message. I think this is not just the issues for the one single countries, but also we have to collaborations to put on the same table the new dialogues, the discussions, topics for the more safer and safeguard data society. So this is the time to collaborate together. Yeah, again, I appreciate it to have a call this time. Thank you for having.
Thank you so much. It was really my pleasure. Thank you.
Thank you.